Anyone who's not done an audio video check, please turn on their video and raise their hand and I will call on them. Morning, Commissioner Gray.
Good morning, John.
How are you doing today?
I'm doing great.
Let's see here. Audio and video look good, sir. You're good to go.
Thank you very much.
Sure.
Mr. Jirak, Mr. Crisp, how are we doing about getting all of our witnesses connected? Are we okay?
Commissioner, this is Harry Judd. I'm on the phone with Mr. Layfield right now, and he's going to work through this with John.
Okay, excellent. We'll stand by. We'll stand by.
Thank you very much for your patience.
Mr. Jirak, how about for you?
I am working on the issue as well, and apologies about the delay.
No problem. We'll stand by.
Mr. McCoy, I believe Mr. Piper is now joined the meeting. Maybe we could, Mr. Piper, if you could turn your video on and test your audio, make sure we can hear you.
Are you able to hear me?
We can. Your video appears to be. You lower your camera, I believe. There you go.
All right.
Mr. McCoy, is that you hearing it well on your end?
Yes, sir. Mr. Piper, can you speak up, please?
Is this any better?
Yes, sir. That's good. I hear you loud and clear. Audio and video look good, sir. You're good. You're good to go.
All right. Thank you.
Commissioner Clodfelter, I believe that Mr. Layfield is now in. Phil, would you do an audio test and turn on your camera, please?
Can you hear me, Harry?
Yes, Phil.
Excellent.
Cannot see you. Would you please turn on your camera feed, your video?
We can see him. His video is working. Thank
Excellent.
You.
Thank you.
I think, Phil, you just turned it back off. It was working. There we go. We can see you now.
Commissioners, again, I apologize for the delay.
That's fine. Let me ask, are we missing anyone else now, or are we all together? All are here who need to be here. Ms. Garrett, I'll look to you for the high sign.
I'm ready. Thank you.
All right, thank you. Madam Court Reporter, if you will please open the record and everyone please come to order. Good morning. I'm Commissioner Dan Clodfelder, and I'm assigned to preside over this proceeding. And joining me this morning via remote connection are Commissioners Lyons Gray and Kim Duffley. We'll take up now for hearing docket number SP-13695 sub 1, which is in the matter of the petition for relief by Orion Renewable Resources, LLC, challenging a decision by the independent administrator of the competitive procurement of renewable energy program, Axion Group, Inc., to disqualify Orion's proposal number 129-01 from tranche 1 of the CPRE program. At this point, pursuant to the State Government Ethics Act, I will remind members of the panel that it is our duty to avoid conflicts of interest and inquire at this time as to whether any member of the panel has a known conflict of interest with respect to the proceeding this morning. Madam Court Reporter, please let the record indicate that no member of the panel identified any conflict. We are here this morning for the limited purpose of considering certain additional evidence that has been presented or has come to the parties and the panel's attention since the original hearing held on November 2nd, 2020. I'm going to try to shortcut some of the procedural follow this morning. So let me proceed and ask counsel to announce their appearances for the record, please. And then we've got some procedural matters we do need to take up. So we'll begin with the applicant.
Good morning, Commissioner Clodfelder, Commissioner Gray, Commissioner Duffley. I'm Ben Snowden with Kilpatrick Townsend for the applicant, Orion Renewable Resources, LLC.
Great. Good morning. Who's next?
Good morning, Commissioner Clodfelder, Jack Durack on behalf of Duke Energy Carolinas, LLC.
Great. Good morning.
Commissioner Clodfelter, Dan Higgins with Bernstein Presnell, appearing along with Mr. Jack Crisp on behalf of the Axion Group.
Good morning to you both. Let me just ask for completeness. I don't see anyone appearing on behalf of the public staff, but I'll ask, is there anyone making an appearance on behalf of the public staff this morning? Let the record reflect that no further appearances have been announced. Gentlemen, I'm going to assume that each, unless you tell me differently by objection, I'm going to assume that each of you has had an adequate opportunity to inspect the clerk's docket and to satisfy yourselves that all matters are properly filed in the docket, belong in the docket, that they are correct and complete, that all confidentiality designations have been properly made by the clerk's filings, and that there are no extraneous or immaterial matters filed in the docket. If any of you disagrees with my characterization of the docket entries, please speak now. All right, then we will proceed this morning, and without a recitation of the procedural history. I know you're appreciative of that. We've got a couple of procedural matters to take up before we begin, and there may be others that I'm not aware of. Let me start with the first matter that is the commission, or the panel's matter, really the commission's matter. Commissioner Gray has a conflict that begins at 12:30 p.m. And I understand that the parties have previously advised counsel for the commission that in the event the hearing today needs to continue past 12:30 p.m., that your client's consent to allowing Commissioner Gray, should he need to do so, to read into the transcript, the remainder of the transcript for which he's not personally present. And will you please confirm to me that that is your understanding? Or if that is not your understanding, let me hear your objection now.
No objection from Ryan, Commissioner.
Great.
No objection from DEC.
No objection for Axion Group.
Thank you for that. Second matter also involves Commissioner Gray. You're popular this morning, Lyons. As many of you know, Commissioner Gray's term expires today, June the 30th. However, the confirmation of his successor is still pending in the General Assembly, and under the law, Commissioner Gray will continue to hold over and serve as commissioner until his successor is confirmed. It is our hope and our expectation that the panel will be able to decide this matter before Commissioner Gray leaves office. However, Chair Mitchell has appointed an alternate commissioner, Commissioner Brown Bland, for this matter in the event that we do not have a decision prior to the time Commissioner Gray's successor is confirmed and his term ends. So long as Commissioner Gray is continuing to serve, Commissioner Brown-Bland will not participate in this matter. However, if Commissioner Gray's term ends before the panel renders its decision in this matter, then I'm going to invite the parties to consider the following proposal. I will not ask you to respond to it today, not presently, but the proposal that we have for you is that if Commissioner Gray is unable to complete his complete decision and before his term expires, that Commissioner Brown-Bland would then step in, and that the parties would agree that the requirements that she have attended in person, the hearings on November 2nd and the hearings today, are waived, and that she be allowed to read in the transcript of those hearings and to examine the evidence and the exhibits offered and admitted into evidence on November 2nd and today. I'm not going to ask you to agree to that this morning. You may want some time to consider that with your client, but we do need a decision from you on that so we can know what happens and what are the contingencies we might need to examine in the event we don't have a decision before Commissioner Gray leaves us. So I'm going to ask you if you would, sorry? I thought I heard someone speak. If not, I'm going to ask you if you would confer with your clients and please advise us by a letter filed in the docket no later than the close of business on July 6th. That's next Tuesday, as to whether your client consents to allowing Commissioner Brown-Bland, in the event she has to step in and replace Commissioner Gray, to read into the record of the case without having participated in person in the two hearings. If there are objections to that, then the panel will consider further options for how to proceed. I won't ask you to comment on that today. I understand that there is an additional procedural matter this morning, and that concerns the sequence of the witnesses. And Mr. Snowden, since that matter was raised by you, I'm going to hear you first on it.
Okay, thank you, Commissioner Clodfelter. As you mentioned, Orion requests that Mr. Lasaki be allowed to provide his testimony first, followed by Duke and Axion witnesses. And there are a couple of reasons that we make that request. Orion is the petitioner in this matter, and it's customary for the petitioner's witnesses to go first in order. Although Mr. Lasaki's testimony is characterized or is captioned rebuttal testimony, and that was really driven by that characterization was pursuant to the to the commission's order setting the testimony schedule for this hearing. Mr. Lasaki's testimony isn't really a rebuttal to the testimony of the Duke and Axion witnesses so much as it is a rebuttal to the late file exhibit, which has been in the record since November. Duke and Axion's witnesses really don't provide much in the way of substantive testimony other than simply to verify the contents of the late file exhibit. So we think it's appropriate for Mr. Lasaki to provide his testimony first, followed by Duke and Axion witnesses. The other reason that we would make this request goes to Commissioner Gray's scheduling constraint. All indications are that the main variable in how long this hearing is going to take is not going to be the examination of Mr. Lasaki. I'm not sure whether the other parties have cross-examination for him, but as far as I can tell, I don't believe they do, or at least not significant cross. And so it's really going to be my cross of their witnesses that drives the length here. I don't think that we're going to be going anywhere near the time constraint, but it would be a lot easier to make sure that we don't go past 12:30 if we can get Mr. Lasaki's testimony out of the way. And then I have a very good idea of how much more there is to be done while I'm examining the other witnesses.
Mr. Snowden, before I hear if there are any objections, and I understand there may be, let me ask you this question. If you were to put Mr. Lasaki up first, do I take it that you would not then be expecting to call him again in rebuttal? You would not be seeking permission to call him in rebuttal later?
That's correct.
That is correct? That is correct.
Yes.
All right. Thanks for clarifying that. Are there objections to the request?
Yes, there are.
All right, Mr. Jarrett, I'll hear you.
Thank you. As we indicated in our communications yesterday to the commission, we believe it's appropriate for the DEC and IA witnesses to go first. When the commission set this particular aspect of this proceeding for hearing, they ordered DEC to file and IA to file testimony first, followed by responsive testimony of Mr. Lazaki on behalf of Orion. And we think it makes procedural sense to follow that order in this hearing this morning, that the party that filed testimony first should be put on the stand first, followed by the party that filed responsive testimony. The substance and procedural posture of the testimony as it was filed should control in this case, we believe. To respond to Mr. Snowden's concerns about timing, we are absolutely sensitive to the timing constraints we're operating under. We have no expectation that we'll come anywhere close to the noon deadline. In fact, Mr. Snowden has previously indicated in an email that he only has an hour's worth of planned cross. We don't have anywhere close to an hour's worth of planned cross at this point, and so therefore the timing concern is a non-issue from our perspective based on the schedule that's been laid out. So we think the manner in which the commission set this matter and requested testimony should control in this case, particularly given that Mr. Lazaki's testimony is very much responsive. It was labeled rebuttal testimony to the direct testimony of the IA and DEC.
Mr. Chris, Mr. Higgins, anything you want to add or say differently?
Nothing to add, Commissioner Clodfelter. As we indicated in the communications yesterday, the independent administrator supports Duke's position on this issue.
Mr. Jirak, let me ask you this question. I think everything you say is quite correct and in line with the way we normally run these things. This is a bit odd in a number of respects, the late file exhibit and so forth. Mr. Lasaki's testimony draws certain inferences about that he believes that the panel should draw from the late file exhibit. And so I think one of the, I predict that it's likely that one of the most important questions that will be posed to the Duke witnesses and the IA witnesses is, do you agree or do you not agree with the inferences Mr. Lasaki has drawn from the late file exhibit? And if you disagree, why? It seems to be, even though it's not the normal order of things, as you correctly point out, it seems to be somewhat logical to just get the thesis put out first from Mr. Lasaki so that your witnesses can then respond to questions about whether they agree or disagree without us having to ask a lot of predicate questions such as, have you read the exhibit? Do you understand the exhibit? Does the exhibit say this? Does Mr. Lasaki's testimony say this? Does he do this? And so forth. It just might be more efficient to put him up, let him put the thesis out there about the exhibit, and then have your witnesses respond. I recognize that that's not the normal procedural posture, but it seems to me that might be most efficient in this case.
Understand that perspective, Commissioner Clodfelter. Obviously, our witnesses have reviewed the testimony of Tim Lazaki, so I think we can really, even if our witnesses, DC and IA witnesses go first, I think we can minimize the predicate foundation laying type questions, given their familiarity with those positions. And so I wouldn't think that that's going to materially change the amount of time we're here this morning. And again, again, just procedurally, I think it would be more appropriate for us to be able to have an opportunity to evaluate the discussion that occurs on the direct testimony in order to evaluate what's appropriately needed in terms of cross-examination of rebuttal testimony.
Mr. Snowden, as I understand your proposal, if you put Mr. Lasaki up first, you will forego any chance for him to respond to things that may be said in the Axion and Duke testimony, and you're comfortable with that? All right, Mr. Jarak, with respect to your observations, I think they're all perfectly correct, but I again think there may be a reason to sort of vary the procedure this morning, and so I'm going to allow Mr. Snowden to put up his witness first, and then we'll take the panel witnesses in whatever order that you want and go from there. I think that may be the most efficient way to proceed this morning. Are there, let me ask Counselor, are there any other preliminary procedural matters we need to take up? I understand that all parties have consented that the Axion witnesses and the Duke witnesses may be put up as a panel. Is that correct?
I think
not
I
aware of
believe
any
that's
objection
correct,
to that.
Commissioner Clodfelter. At this point, I think the plan is to have the IA witnesses presented separately from the DEC witnesses.
I understand, but for each party, they'll be put up as panels.
Yeah,
respectively.
my apologies. That's correct.
No, great. That's great. Anything else by way of preliminaries?
Anything else for here?
All right, Mr. Snowden, you may call your witness.
Thank you, Commissioner. Orion Renewable Resources LLC calls Timothy Lasaki to the stand.
Mr. Slotky, will you please raise your right hand? Do you solemnly and sincerely affirm that the testimony you're about to give this morning will be the truth, the whole truth, and nothing but the truth?
I do.
Great. Mr. Snowden, proceed.
Thank you. Mr. Lasaki, can you please state your full name and business address?
Full name is Timothy James Lasaki. Business address is 155 Grand Avenue, Suite 706, Oakland, California, 94612.
And by whom are you employed and in what capacity?
I am employed by Orion Renewable Energy Group, LLC, as the Vice President of Origination and Finance.
And did you cause to be filed in this docket pre-filed supplemental rebuttal testimony consisting of 9 pages and 1 attachment filed on May 12th, 2021?
Yes, I did.
And if I were to ask you the same questions today, would your answers be the same?
Yes, I would. Yes,
And did you also cause, and did you also cause to be filed pre-filed second supplemental rebuttal testimony consisting of 3 pages and 1 attachment filed in this docket on June 21st, 2021?
Yes.
And if I were to ask you the same questions today, would your answers be the same?
Yes.
Do you have any corrections to your pre-filed supplemental rebuttal testimony or your pre-filed second supplemental rebuttal testimony?
No.
Commissioner Clodfelter, I would ask that Mr. Lasaki's pre-filed supplemental rebuttal testimony, as well as his pre-filed second supplemental rebuttal testimony, be received into the record as if given orally from the stand.
Without objection? They are so received.
Thank you. I would further ask that the attachments to Mr. Lasaki's testimony be moved into evidence at this time.
Do you want to move them into evidence, or you want to mark them for identification?
I'd like to mark them for identification.
They will be marked as so marked as filed. Someone's got a microphone on, because I'm getting feedback and an echo of my voice. If you're not speaking, please put your microphone on mute. Thank you. That cured it. Thank you. All right, Mr. Snowden, I think I just granted the motion to admit the testimony and mark the exhibits. Let me advise counsel that you can presume that the panel have received and have read or will read your summaries, and that it is not necessary this morning to read summaries of the testimony.
Okay, well, we can, if the commission would, or the panel would prefer to skip the summaries, we can skip Mr. Lasaki's summary. Would that be your preference?
We're all good readers.
Okay, thank you, Mr.
It would be the preference.
Okay, well then, at this time, actually, Mr. Clodfelter, Mr. Lasaki is available for cross-examination and commissioner questions.
Great. I'm not sure who wants to go first, but I'll let you go in whatever order you choose.
Thank you, Commissioner Clodfelter. If it's all right, I will proceed with some brief cross-examination.
Please proceed.
Thank you. Mr. Lasaki, I want to just ask a few brief questions regarding your initial rebuttal testimony. And this concerns assertion statements made on page 8 of your initial rebuttal testimony. Do you have a copy of that in front of you?
I'm going to open it now.
Thanks. Let me know when you're ready.
What was the date of the document you're referring to?
I don't have the date of filing. It's your pre-filed supplemental rebuttal testimony of Timothy Lasaki on behalf of Orion Renewable Resources.
I believe it's May 12.
Okay, yes, I have that open now.
Can you please turn to page 8, line 18?
Yes, I have that.
And I want to specifically ask about your statement beginning on page 22, but to begin with here, you are responding, I believe, in this portion of the testimony to the assertions or the statement in the late file exhibit that asserted that the Orion's Tranche 1 proposal was quote unquote detrimental to customers. Do you recall that portion of your testimony?
I do.
Okay, and your statement in your testimony here, beginning on line 22, says the claim that the proposal is detrimental to customers makes very little sense. Can you explain what you mean by makes very little sense?
Yes. My view on that is that there was a standard set, that it was the avoided cost standard under House Bill 589. And it is the public staff whose job it is to look out for ratepayers agrees with this definition of what makes sense for the customers.
So you understand, do you not, that the statement that the project would be detrimental to customers was based on the results of the IA's net benefit analysis?
I do not believe that was the standard that was to be used under the RFP.
That's the question, though, I'm asking is the statement that was made that the project is going to be detrimental to customers was based on the results of the IA's net benefit analysis. Putting aside the legal question of what is the appropriate standard, that statement itself was based on the results of the IA's net benefit analysis.
I do not believe our project was going to be detrimental to our customers based on the established definitions of cost effectiveness and our bid decrement that was below avoided cost. So mathematically, I believe our project was beneficial to customers.
Okay, are you familiar with the net benefit analysis and the mathematical outcome of that analysis?
I'm familiar with that analysis as well as the fact that it was to be used for rank order only.
So you're aware of how are you familiar with how the net benefit analysis worked, Mr. Lozaki?
I'm familiar with the mathematical calculation and how it was applied.
So you're aware that the net benefit analysis assessed the value of the output of the project against on an hourly basis against the avoided costs on the DE system over that same period of time, correct?
I believe that it was used to assess the hourly values in terms of how that compares to avoided cost. Our project was bid at a decrement to avoided cost.
But you don't disagree with the fact that the IA's analysis was an hourly comparison of the cost of your project against the hourly avoided cost in the Duke system over the 20-year period of the PPA.
What doesn't make sense to me is how you can have two different mathematical outcomes using similar data. So I do understand that an 8760 of hourly rates were used by the independent evaluator. That same 8760 hourly rates were not provided to bidders, so I did not have a copy of that. I only had a copy of the avoided cost amounts, to which I was only able to bid a decrement of $1.
Were you aware that the avoided cost amounts that the IA used in its net benefit analysis were the same avoided costs that were rolled up into the levelized price caps proffered in the RFP?
I was not aware, and I also, to me, see a mathematical discrepancy in that how could one bid be both above and below the same thing? So if we're talking about avoided cost, we bid a decrement of $1 below avoided cost.
Can you point me to your testimony anywhere where you've identified a mathematical error in the IA's net benefit analysis?
I don't believe there was a mathematical error. I think that net benefit potentially used figures that weren't part of the RFP or made available to bidders.
So you agree there was no mathematical error. Do you have any evidence or do you have any testimony to indicate that to counter the IA's assertion that the same set of avoided costs that were used to establish the avoided cost cap were the same avoided costs that were used in the IA's net benefit analysis?
I believe that's a question that should be directed to the IA and not to me. What I am aware of is that our project bid a decrement to the avoided cost standard.
Okay. So do you disagree with the assertion that when the IA conducted its net benefit analysis and stacked up the costs of the Orion PPA that would be incurred by customers if the Orion PPA was executed in tranche 1 against the cost that customers would incur in the absence of the Orion PPA, that customers would pay more costs on a projected basis for the Orion to have the Orion PPA serving system needs than were it not the case the Orion PPA were serving customer needs?
I believe we're revisiting material that was discussed in November 2020 at this point.
I'm sorry, could you repeat that, Mr. Lozaki?
I believe we're revisiting the topics and material that was already covered in the November 2020 hearing. And it's also my understanding that this is only related to the late filed exhibit where there was a statement that 15 other projects, if had been subject to the same avoided cost standard that was discussed in November 2020, may have instead been awarded a PPA.
Actually, Mr. Lozaki, I'm asking you questions related to your rebuttal testimony in which you have asserted that the statement that the proposal is detrimental to customers makes very little sense. That's the testimony that I'm discussing with you right now. Would you agree that that's your testimony?
As Orion discussed in its filings under House Bill 589, that sets the standard of cost effectiveness for resources procured under the CPRE program, the utility's published avoided cost rate.
Okay, but Mr. Lozaki, the IA's net benefit analysis, looking at the cost of the Orion project over 20 years and comparing it against the costs that would otherwise be incurred for customers, showed that customers would pay more by executing the Orion Tranche 1 PPA than if it did not. Do you think and would you agree that you have not identified any mathematical error in the IA's analysis that came to that conclusion?
I'm going to object to Mr. Dragon's already asked this question.
Our proposal would not result in customers paying more than the avoided cost. It was only possible.
Mr. Lasaki, hold a second. There's an objection to the question. I need to hear the objection.
Okay. Thank you, Commissioner. I just object. This question has been asked. This precise question was asked a few moments ago, and the previous question has also been asked. So I think we're retreading ground that Mr. Dirac has asked questions on several times.
I think we are drifting a little bit here, but I'm going to allow the question and let's get an answer. And then again, let's try to stay focused as much as we can on the new matters and not revisit matters that we debated in November. But Mr. Dirac, I'll allow your question and I'll allow the answer. You want to restate your question?
Sure. Mr. Lozaki, have you identified any mathematical error in the IA's net benefit analysis that showed that customers would pay more money under a scenario in which it executed the Orion Tranche 1 PPA than if the company did not execute the Orion Tranche 1 PPA?
A two-part answer. First of all, that mathematics that you're describing has not been made available to me. And second of all, our proposal was below a decrement bid below the avoided cost, which is the standard that was established under House Bill 589 to set the cost effectiveness for resources procured.
Okay, I have no further questions at this time.
All right, thank you. Mr. Chris, Mr. Higgins, I'm not sure who's going to be examining this morning, so whichever of you.
Commissioner Clodfelter, we don't have any questions for Mr. Lasaki.
All right, thank you. Mr. Snowden, any redirect?
No, sir, I do not have any redirect.
All right, let's see, Commissioner Gray or Commissioner Duffley, any questions?
I have no questions at this time.
Thank you.
No questions for Mr. Lozaki.
All right, and likewise, I have no questions either. So, Mr. Snowden?
Commissioner, we would ask that the attachments to Mr. Lozaki's testimony be moved into evidence at this time.
Without objection, they will be admitted into evidence. Thank you. Anything further, Mr. Snowden?
No, sir, not for Mr. Lazaki.
All right. Any other witnesses? Not aware of any, but I have to ask.
No, sir, we have no other witnesses for Orion.
Okay, thank you. All right, now, we discussed at the beginning the order of proceeding as to Orion, but we didn't really discuss who's going to go next. So I'm indifferent, and we'll take it at your pleasure. Who's going to go next?
Mr. Higgins, any particular preference on your end? We did not coordinate ahead of time.
I couldn't hear you.
Mr. Higgins or Mr. Crisp, any particular preference on?
None here. We're fine with.
I
either way.
recommend the IA witnesses go first if that's all.
All right, let's, Mr. Higgins, let's take your witnesses first. Let's get them all up on the screen. And be sure we have them all. Why don't you just read off the names of the panel members so we be sure we have everybody.
All right, sir. The panel will be Harry Judd, David Ball, Philip Layfield, Ralph Salvacci, and Gary Rozier, with my apologies for mispronouncing anyone's name.
All right. I think I see everyone. Go ahead.
Do we have everyone on the screen?
I think I see everyone on the screen. All right, gentlemen, will each of you raise your right hands? Okay, do you and each one of you solemnly and sincerely affirm that the testimony you are about to give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Madam Court Reporter, just so the record, Madam Court Reporter, just so the record's clear, let's be sure that the record reflects that each one of the panel members affirmed, gave the necessary affirmation. All right, Mr. Higgins.
Commissioner Clodfelter, since we're putting these folks up as a panel, I would propose to sort of get each one of them to authenticate their testimony and then move its admission because their testimony was consolidated, if that's acceptable to you.
That is acceptable. Please proceed.
All right. I'll start with Mr. Harry Judd. Mr. Judd, are you with me?
Yes, sir.
Please state your name for the record.
Harold Judd, J-U-D-D.
And were you part of the Axion team that worked on tranche 1 and 2 of the CPRE program?
Yes,
Did you participate in the hearing that was held in this docket on November 2 of last year?
I did.
Did you file testimony in this docket in April of this year?
I did.
Or do you have any, excuse me, do you have any changes or revisions to your testimony?
No, sir, I do not.
If I asked you the questions that are set forth in your pre-filed testimony, would your answers be the same as those appearing in your pre-filed testimony?
Yes.
Next, Mr. Clodfelter, I would move to David Ball. Mr. Ball, are you with me?
Yes.
Would you please state your name for the record?
David Ball.
And were you part of the Axion team that worked on the tranche 1 and tranche 2 parts of the CPRE program?
Yes.
Mr. Ball, did you participate in the hearing last November?
Yes, I did.
Did you later file testimony in this docket in April of this year?
Yes.
Do you have any changes to your testimony that was pre-filed?
No.
If I was to ask you the questions that are set forth in your pre-filed testimony, would your answers be the same as those appearing in the pre-filed testimony?
Yes.
All right, sir, thank you. Now I'll move to Mr. Philip Layfield. Mr. Layfield, are you with me?
Yes, sir.
State your name for the record, please, sir.
Philip Layfield.
And were you part of the Axion team that worked on Tranche 1 and Tranche 2 of the CPRE program?
Yes, I was.
And did you also participate in the hearing in this docket last November?
I did.
Did you later file testimony in this docket in April of this year?
I did.
If I was to ask you the questions that were put to you in the pre-filed testimony, would your answers be the same as those appearing in the pre-filed testimony?
Yes, they would.
Any changes or corrections?
No, sir.
Thank you, sir. Next, Mr. Ralph Monsalvaci. Mr. Monsalvaci, are you with me?
I am with you.
Please state your name for the record.
My name is Ralph Monsalvaci.
And were you also part of the team, the Axion team that worked on Tranche 1 and Tranche 2 of the CPRE program?
Yes,
Did you participate in the hearing held in this docket last November?
yes, I did.
Did you pre-file testimony in this docket in April of this year that consisted of some written questions and answers?
Yes.
Do you have any changes or corrections to your pre-filed testimony?
No, I do not.
If I was to ask you the questions that are set forth in your pre-filed testimony, would your answers be the same as those that appear in the pre-filed testimony?
Yes.
Right, sir, thank you. Now, I'll move to Mr. Gary Rozier. Mr. Rozier, are you with me?
Yes, I'm here. Do you not see me? Oh,
Please state your name for the record.
my name is Gary Rozier.
All right, sir. Were you part of the Axion team that worked on Tranche 1 and Tranche 2 of the CPRE program?
Yes, sir.
Did you participate in the hearing in this docket last November?
Yes,
Did you later pre-file written testimony in this docket in April of this year?
yes,
Any changes or corrections to your testimony?
no, sir.
If I was to ask you the questions that appear in your pre-filed testimony, would your answers be the same as those that are set forth for you in that pre-filed testimony?
Yes, they would.
Mr. Clodfelter, at this point, that's all 5 members of the Axion panel. I would move the admission of their pre-filed testimony into the record as if given orally from the stand.
All right, and unless I hear an objection, and I hear none, testimony will be so admitted.
All right, sir. Also, given your insight regarding the summaries, we'll dispense with the reading of any summaries, and the panel is available for questions.
Very good. Who's up first? Mr. Jarak, do you have any questions for this panel?
No, DEC does not have any questions for this panel. Thank you.
Thank you. All right, Mr. Snowden, we're with you. Mr. Snowden, you're on mute. Mr. Snowden, you're on mute.
Thank you, sir. Sorry about that. Good morning, gentlemen. It's nice to see you all. And I am, for the most part, my questions are going to be directed just simply to the panel. So whoever is best suited to answer those, please pipe up. And this is, I guess, this is a sort of general question about the late filed exhibit. Is it your understanding that at the hearing in November, the commission directed Axion and Duke to collaborate on the development of the late filed exhibit?
It's Harry Judd, I'll answer that. Yes, but that's how we read the order.
Okay. Thank you, Mr. Judd. And what was the purpose of that late filed exhibit?
To address concerns of the commissioners as raised during the hearing.
Okay. But the late filed exhibit did go beyond answering sort of specific concerns raised by the commission at the hearing, didn't it?
I'd be happy to answer your questions if you want to, Ben, help me understand where you're going with that.
Sure. Let me ask it this way. So as you say, there were specific questions that the commission had or that the panel had during the hearing that were addressed in the late filed exhibit. Is that right?
Yes.
But the late filed exhibit included a lot of information that went beyond the specific concerns that were raised by the commission at the hearing. Is that correct?
I don't see it that way, but continue, please.
So you don't think that the late filed exhibit included information that went beyond addressing the specific questions raised by the commission?
I think the late filed exhibit speaks for itself, Ben. The information is there to be used by the commission.
Okay. Could you describe the collaboration process between Axion and Duke in the development of the late filed exhibit?
In the same process that was used, and for me to stop for a moment, Commissioner Clodfelter, I too am getting feedback. If that's not disturbing to you, I'll simply continue. Thank you.
It appears someone may have a microphone open who's not speaking. So if you are not speaking, please mute your microphone.
I think I am the culprit with that, so I'll try to mute myself.
Ben, if you want to stay muted for the rest of the hearing, we won't object. So in the same way that we conducted CPRE, which is, there was step 1, step 2, we, in creation of the late filed exhibit table, which was strictly the role of the IA, we looked to the Duke personnel to assist in the system upgrade cost calculations.
Okay, and you're getting to where I'm going. The late filed exhibit consists both of several pages of narrative and also a table of information about certain tranche 1 proposals. Is that right?
Yes, because that's what we understood that the commissioners wanted us to include.
And Axion provided the information for that table, I think, with some input from Duke. Is that right?
The table was created by Axion, and yes, as I just stated, we looked to Duke T&D evaluation team to assist us in the numbers that we didn't have previously. Yes.
Okay. Was Axion involved in the preparation of the narrative portions of the late filed exhibit?
Only to the extent that it referenced the table, but the rest of it was produced by Duke.
Did Duke, so Duke drafted the narrative portions of the late filed exhibit, is that right?
They provided that part of the late filed exhibit, yes.
Okay, and did Duke share the narrative portions of the late filed exhibit with Axion prior to it being filed?
I don't recall, actually. I don't recall.
Okay, so you don't recall whether anyone from what does anybody else on the panel recall whether Axion reviewed the narrative portions of the late filed exhibit for accuracy or for any other reason before it was filed?
This is Gary Rozier. I did not.
Dave Ball, I did not.
Ralph Malzovich, I did not.
And Phil Layfield did not.
Okay, thank you. That's very helpful. So, Mr. Judd, you don't recall whether you reviewed the narrative portions of the late filed exhibit?
That is my testimony, yes.
Great. So the late filed exhibit discusses the fact that other proposals besides Orion were eliminated from CPRE based on a net benefit analysis, doesn't it?
Yes, and if you're getting to the clarification we provided on June 14th, where we clarified our response to the commission's request, yes, absolutely.
Okay, well, I'm not quite there yet. We'll get to that in a minute. So 2 projects besides Orion's were eliminated in step 1 based on the net benefit analysis, correct?
Yes.
Okay. And other projects were eliminated in step 2 based on that net benefit analysis, correct?
As we presented in our clarification, Ben, I'm not quite sure I understand your question, so I'm going to answer what I heard. As we presented in our clarification, there were a number of projects that were not evaluated in step 2 by Axion because we did not get back the a system upgrade cost to be imputed to the bids, but were eliminated because they would be above the avoided cost limit.
Okay.
If that's the question, I apologize and please restate it, but that's what I thought I was being asked.
That's not the question, but I think we can streamline this a little bit. Mr. Judd, if you don't mind, do you have a copy of the late filed exhibit?
I do.
Okay. And if you don't mind looking at page 7.
I have it in front of me.
Okay. You see where it says 15 projects were also eliminated in tranche 1 based on a determination of negative net benefits after the application of D&D costs determined in step 2. Extensive further analysis would therefore be needed to assess each such proposal to determine whether the applicable T&D costs, in addition to causing the proposals to have a negative net benefit, also would have exceeded the maximum allowable T&D upgrade cost. Do you see that?
You read very well. Yes, I see that.
Thank you. I tried. So would I be correct in understanding that this statement was drafted by Duke?
Yes.
Okay. And you don't recall whether you would have reviewed this statement prior to the late filed exhibit being filed?
That is correct.
Okay. And I read this to say that it would take extensive further analysis to determine whether any of the 15 projects eliminated during step 2 were actually below avoided cost. Is that how you interpret that as well?
I'm pausing, and because it's actually written as they would exceed the allowable, not that they would be below avoided cost, but rather how far above avoided cost is the approach that we used.
Okay.
And that's why we stopped doing initial analysis, because we were assured that the system upgrade cost would be so extensive that they would be above avoided cost, as well as fail our net benefit analysis.
Mm-hmm. And just to be clear, I'm not, we will talk in a minute about the 6 projects that were eliminated due to transmission constraints. I'm not trying to get at that right now. I'm just confirming that we have a mutual understanding of what this statement means in this context. And I interpret this to say, or this to be a claim that extensive further analysis would be required to determine whether any of the 15 projects eliminated in step 2 based on the net benefit analysis would actually be below avoided cost. Is that your understanding of that statement?
Ben, we addressed this in our clarification that we didn't analyze those 15 projects with the understanding, because they were cited in the pre-identified constrained areas, that the system upgrade cost to meet the RCOD would be extensive, and therefore they would fail on both bases.
Okay. Well, okay. So let me ask you this. So you're talking about the 6 projects eliminated due to a transmission constraint. Is that right?
I was talking about all 15, but as far as the 6 go, yes, they were in constrained areas, which it was not physically impossible for a system to be built to meet their need, but the cost of that system upgrade would be so extensive that once those costs were imputed to the bids, they would, of course, fail both our net benefit test and the avoided cost.
Okay. Okay, thank you. So for those 6 projects, we now know without any further analysis that those projects are not below avoided costs. Would you agree with that?
Yes.
Okay, thank you. If you don't mind, I'd like to. Do you have Mr. Lasaki's pre-filed second supplemental rebuttal testimony? And its
I do.
attachment.
Yeah, it'll take a moment, please.
Okay.
Is it the May 12th, Ben?
No, that was the
June 21.
June 21. Thank you. Yes.
Thank you.
And I'm specifically looking at the attachment B to that testimony.
I have it in front of me.
Okay, thank you. And you recognize this document?
I do.
Okay, and this was the document that was produced by Axion in response to the order of the commission on the motion to compel?
That is our June 14th clarification filing to the commission. It's part of it, yes.
Okay, thank you. And could you please look at page 3 of that? That's the table.
Yes, I have it in front of me.
Okay, and going back to the 6 projects that were eliminated due to transmission constraints, those are the ones that are bolded in the column marked Duke T&D evaluation team step 2 system upgrade costs, right?
Yes, the bolding's copy I have it's a little faint, but yes, I see the 3. Yes.
Okay, thank you. And those are proposals, I have those as being proposals 9, 14, 17, 21, 24, and 26. Would you agree with that?
Okay, let's do our cross-reference. You're a little quicker than I am, but that's not unusual. Number 9, number 21, number 24, number 26.
Yes, and also number 14 and number 17. And I think an easy way to tell is those are all the projects that have a positive net benefit number in the net benefit column.
I have them identified, yes.
Okay, so 14 and 17 are on that list. Is that right?
Yes, they are.
Okay, and so we know now that those projects are not below avoided cost. Would you agree with that?
Avoided cost.
Could I possibly help clarify this?
That's Mr. Rozier, and I would appreciate, since we are sitting at a panel, Ben, if we have Gary join us.
Absolutely. Thank you.
I just want to be sure we're using the correct terminology here. So where Mr. Judd is talking about below avoided cost, that's specifically this additional test that came up in tranche 2, not in tranche 1. That was to basically pass along projects that pass this, what I would call the statutory avoided cost, as perhaps Duke and the staff agree with that. But from an Axion perspective, every project that didn't pass our detailed 8760 cost benefit was above avoided cost for Duke customers.
Thank you, Mr. Roger, for that clarification. And I appreciate that. When I say below avoided cost, above avoided cost, I'm referring to the statutory avoided cost cap and not to the net benefit analysis. So I appreciate that clarification. So I'm Mr. Roger, I'm not sure whether you or Mr. Judd or someone else is the right person to answer this, but would you all agree that we now know with the information provided in this table, and I think in a prior the predecessor to this table that was produced by Axion, that those 6 projects were, or those 6 proposals were not at or below the statutory avoided cost cap. Is that right?
Yeah, Mr. Snowden, I did not participate in that table, so perhaps Mr. Monsivaci and Mr. Ball can answer that question.
Ralph, did you want to contribute?
Yes, I would like to. With respect to Mr. Snowden, I'm not sure which columns you're comparing, and I'll be glad to answer the question.
Thank you. Well, maybe I'll ask it another way. Would you agree that those 6 projects that we are referring to right now would have been eliminated from CPRE, even if they were below avoided cost? I should strike that. Let me rephrase that. Those projects were eliminated from CPRE because of uncertainty associated with their interconnection. Is that fair to say?
That's outside of my scope of knowledge, but
well, permit me, Ben, as I said a few moments ago, because of the cost of system upgrades that would be needed to overcome the constraints for where those projects were loaded, or excuse me, would load the system, the circuits into which they would deliver, the system upgrade cost would be so dramatic that the projects would be above avoided cost. And because you're referring to the time constraint, if we put 3 shifts of workers on it and brought in the Army Corps of Engineers, and the commission was prepared to approve significant system upgrade costs, they could have been constructed, but that added cost would have necessitated a significant imputed cost to those projects, which is why we stopped and did not have those in our step 2 analysis.
Okay, thank you for that. I'd like to talk about the other 9 projects on this chart then. And would you agree that those projects were the ones that were eliminated based on their having a negative net benefit analysis?
Those were all part of projects that were not passed back to us, as we said in our clarification from Duke, with the representation that the system upgrade costs would be quite significant. If you look at the numbers involved here, 40 million, 44 million, 20 million, and then you look at the column maximum allowable T&D, the analysis was stopped as being unlikely to produce a positive result for the project. So Ralph did not include those in our step 2 re-ranking.
Yeah. Oh, Mr. Judd, I'm sorry. I'm not talking about the 6 projects that we've just been discussing. I am not talking about those. I'm talking about the other 9 projects of the 15 on this list. Are you with me?
I understood your question.
Okay. So it's my understanding that those 9 projects were eliminated based on their having a negative net benefit with T&D costs. Is that right?
Ralph, were the other 9 projects passed back to you with T&D costs assigned to them?
Not prior to constructing this table.
And this table was the one you were referring to is the one produced in response to the commission's request. The date on it is October, strike that, June 21st, 2021. Well, 2 years past our conclusion of tranche 1. Is that correct? Am I understanding you?
That's when the document is dated. Well, let me back up. So the late filed exhibit references 15 projects that were eliminated from step 2 based on their having a negative net benefit analysis. Is that right?
Yes.
Yeah. Okay. And this table provides information about those 15 projects. Is that right?
It does.
Okay. And we've already discussed 6 projects that were, although they were grouped with those 15 in the late filed exhibit, they were actually eliminated for reasons related to transmission constraint. Presumably they would have had a negative net benefit analysis because their interconnection costs were very, very high. Is that fair to say?
I'll say again, just to be clear for the commissioners, as Ralph just said, they were not passed back to us with system upgrade costs assigned to them. So he did not complete the step 2 re-ranking of bids for those 15 projects because they were identified as ones that would have very large system upgrade costs and therefore, excuse me, would be above awarded costs, and therefore he did not use his modeling to rank them.
And Mr. Snowden, just again to clarify, you're using the term interconnection costs. Mr. Judd is talking system upgrade costs. System upgrade costs are paid by the customer. Interconnection costs are paid by the market participant. So when Mr. Judd is talking these costs, that's the bucket he's putting it in.
Yes, understood. Thank you. Yeah, if I say interconnection costs, I apologize for being imprecise. I'm referring specifically to upgrade costs. And I really do want to move on from these 6 projects. I think we've discussed those. We've got plenty of discussion on those. I really want to talk about the other 9 projects that are on this table. So would you agree that those other 9 projects were eliminated as described in the late filed exhibit based on their having a negative net benefit?
I would refer you again to our clarification where we, that characterization in late filed exhibit was, excuse me, a summary statement of we understood they would be above awarded cost, but we, as stated now again, and as clarified in our filing, we did not rank them, re-rank them because we did not get back system upgrade costs for those projects for our step 2 analysis.
But you did get back system upgrade costs for these other 9 projects, didn't you?
When, as Ralph testified, when this table in our clarification was produced, yes, at that point, in preparation of this table, we received those numbers. The ones.
Okay, so you have information about the upgrade costs for the 9 projects on here that are not the ones we've been discussing, the 6 that we've been discussing. Is that right?
The information we have is presented on this chart that we provided in our clarification on October 28th.
Okay. Mr. Judd or anyone else on the panel, can you explain to me the concept of maximum allowable T&D upgrade costs?
Let me take a run. Oh, I'm sorry.
I'm Ralph Monteverci. I'll be glad to explain.
Thank you.
The maximum allowable transmission calculation is specifically a calculation of the decrement and the amount of energy coming from the facility. For instance, a 50 megawatt facility bidding a $2 decrement would have approximately 110,000 megawatt hours of output. And therefore, with a $2 decrement, it has $220,000 to fund transmission over a 20-year period. And that basically equates to a net present value of about 2.35 million. And then you have to take that to a capital cost, which is approximately 2 million.
Okay, thank you for that. Thank you for that explanation.
Thank you.
I'm sorry, you finished with your answer?
Yes, thank you.
Okay. The late filed exhibit, and I'm looking at page 1 here, describes this as the maximum amount of upgrade costs that could be absorbed by a proposal before exceeding the avoided price cost cap. Is that accurate? Or is that an accurate description of what maximum allowable T&D upgrade costs is?
Excuse me, Ben, Dan Higgins,
Yes.
Could you give me a reference in the late filed exhibit as to where you're referring to?
I am looking at page 1 of the late filed exhibit. It is in the 3rd paragraph, and I'll just go ahead and read it. It says, as requested by the commission, the IA has also calculated the allowable system upgrade cost that would have been applicable in tranche 1 for these 3 bids. Those were the ones that were eliminated in step 1, i.e. the maximum amount of upgrade costs that could be absorbed by the proposal before exceeding the avoided price cost cap, though the projects had a negative net benefit. Do you see that?
Yeah, I see it. I'm with you.
Okay.
I was just asking for a reference.
Yes. Okay. Let's see here. And Mr. Monsalvace, sorry, is it Monsalvace?
Yes, Monsalvace.
Monsalvace. Okay, thank you, Mr. Monsalvace. Do you see that description in the late filed exhibit?
Yes.
Okay, and is that it appears to me that that's describing the maximum allowable T&D upgrade cost figure. Is that right?
As it was drafted for tranche 2, and now it's being retroactively applied to tranche 1.
Okay, thank you. So Axion calculated the maximum allowable T&D upgrade cost for each project that was advanced to step 2 of tranche 2. Is that right?
That is correct.
Okay, and why did it do that?
Because that was part of tranche 2. That was stated that we would do that in tranche 2.
Okay.
If I could, Ben, the goal there was to avoid unnecessary continued analysis and evaluation and pricing assignment by the T&D evaluation team. As you well know, if you put a challenge in front of engineers, they'll come up with a solution, but it does come to a point where if they keep on analyzing, keep on identifying additional costs, it was not going to better the bid, as it were. So in the interest of efficiency, the numbers were given as a benchmark to say, if you hit this, you really don't have to take it out and find the millions and millions of dollars beyond that to establish the impact.
Okay, thank you for that. So as I understand what you're saying, or this is my interpretation of what I'm hearing from you, is that for purposes of tranche 2, this figure was calculated so that Axion or Duke's team could easily tell whether a particular proposal was going to go over the avoided cost cap, the statutory avoided cost cap. Is that right?
It was a benchmark for guidance, yes.
Okay. And so if the upgrade costs associated with a particular proposal exceeded the maximum allowable T&D upgrade costs, you would know that that proposal was going to be above the statutory avoided cost cap. Is that right?
This is Gary Rozier again. Yes, you would know that, but the cost benefit is separate. In fact, there are projects that might have been bid in that had greater energies and hit the sweet spots on avoided cost hour to hour, and you could actually pass the cost benefit test and not the statutory avoided cost test. That was the value we had of looking at every project on its own with its energies. And that's why we recommended the ones that only passed the cost benefit test went forward in tranche one. Subsequent to that, these issues about the statute, et cetera, came up, and that created this tranche two additional calculation.
Okay, understood. Thank you. But just, I want to make sure I'm clear on this. For a particular proposal in tranche two, if the upgrade cost as calculated by Duke are in excess of the maximum allowable T&D upgrade costs, then that proposal is above the statutory avoided cost cap. Is that right?
In tranche, just to clarify, Ben, you want us to talk about what we did in tranche two. That's what I just heard.
Start with tranche two, yes.
Gary? Ralph?
I wasn't, could you repeat the question, Ben?
Sure. So for any given tranche two proposal that made it to step two, if the T&D upgrade costs as calculated by Duke exceed the maximum allowable T&D upgrade costs, then that proposal is above the statutory avoided cost cap. Is that right? I think you're on mute. Sorry, Mr. Rozier.
Went the wrong way.
Mr. Rozier, you're on mute.
I know, I went the wrong way with it, Ben. That is absolutely true, with the caveat that we would not have eliminated it if the detailed cost benefit showed it was positive for customers. In other words, you had to fail both tests in tranche two.
Okay, thank you. So I want to look back at tranche one. For a given tranche one proposal, it would also be the case, wouldn't it, that if the maximum allowable, well, for a given tranche one proposal, it would also be the case, wouldn't it, that if the upgrade cost as calculated by Duke exceeded the maximum allowable T&D upgrade costs, then that proposal was over the statutory avoided cost cap, right?
I guess I'll answer that. Yes, with the same caveat I said about tranche two, which is the way tranche two worked.
Okay, thank you. So I want to go back to attachment B to Mr. Lasaki's testimony, the table we were looking at, the table of the 15 projects. Are you with me?
March on.
Okay, so if we look at this table and we compare the Duke T&D evaluation team step two system upgrade cost column to the maximum allowable T&D upgrade cost column here, we know that if the upgrade cost column exceeds the maximum allowable T&D upgrade cost column, we know that that proposal is above the statutory avoided cost cap, correct?
Let me just say, Ben, none of these panelists are testifying as attorneys, and including myself, because I'm hardly an expert on North Carolina law, and you know I'm not admitted there. So to say the statutory, to the extent that gets into the whole argument that you're having with that you and Duke counsel have weighed in on, and the interpretation of the statute, we're really not going to weigh in on that. I trust that's not what you're asking us.
Yeah, no, understood. Yes, I am not assuming that you are agreeing with our legal position on the avoided cost cap. I'm absolutely clear about that. Not playing gotcha. I just
No,
want
I didn't think you would, but for the benefit of the, look, you and I don't have that relationship. We don't play gotcha with each other, but for the benefit of the commissioners, I just wanted to clarify that. Thank you.
Yeah, absolutely. So do I need to repeat? Do I need to repeat my question? It was.
Is the question, I believe the question was, if the maximum allowable T&D upgrade cost as shown on our table in our clarification filing exceeded the T&D evaluation step 2 upgrade costs as also shown on the table, that there was not further analysis and it was deemed that the imputing that cost would put it above avoided cost. That was the question, I believe.
Yes, that's my question.
The answer is yes.
Okay, great. Thank you. So let's go to the table. So there was, of these 15 projects, 6 projects were eliminated from CPRE because they had not analyzed, but very, very high system upgrade costs. Is that right?
Yes.
Okay, and 9 projects, the remaining 9 projects were all above the avoided cost cap because their upgrade costs exceeded the maximum allowable T&D upgrade cost. Is that right?
Yes.
Okay.
I believe so.
Okay.
Yes.
So going back to this, looking back at the late filed exhibit, at the statement in the late filed exhibit that says extensive further analysis would be needed to assess each proposal to determine whether the applicable T&D costs, in addition to causing the proposals to have a negative net benefit, also would have exceeded the maximum allowable T&D upgrade cost. So we now know the answer to that question, don't we?
Well, we know what's shown on the table. And again, Ben, there comes a point where it's pencils down because the extent of the impact wasn't calculated. But
Okay. Well, let me ask it another question. At the hearing in November, and I'm not, Mr. Ball, it might have been, it's not clear from the transcript, Mr. Ball, I'm not sure if it was you or another witness from Axion who briefly discussed the possibility that there were projects eliminated in step 2 based on net benefit analysis that would have been below avoided costs. Do you recall that?
Yes, I do.
Okay. And that's what this whole discussion is about, right? Whether any of those projects that were eliminated in step 2 would have passed the avoided cost, the statutory avoided cost cap test.
Yes, it was uncertain at that point in time.
Okay. And we now know, based on the information in this table, that the answer to that question is no. Is that correct?
If you're saying that of the 15 proposals, would any of them be eligible to move forward? I think the conclusion from the table is no, none of them could move forward.
Okay, thank you. And let me ask one further question.
I'd like to add, we did not know that in November when we had the hearing.
Okay, understood. Did you know that when the late filed exhibit was filed?
No, we did not. And it's true, extensive analysis needed to be done to analyze that and to prepare that table, the subsequent table that is in Lasaki's testimony.
Okay, and when you say extensive analysis, what do you mean?
We had to prepare the table and run the analysis through our model and all that.
Okay, so you had to calculate the maximum allowable T&D upgrade costs for each of these projects?
Mr. Snowden, I think that the extensive analysis is what Mr. Judd was talking about, of knowing there are a lot of transmission improvements to be made, et cetera, getting a detailed quantified number for that was the extensive analysis that would need to be done.
Okay, but you concluded during step 2, sort of based on, I don't want to say eyeballing, but based on, well, in step 2, you or Duke drew the conclusion based on the, I guess, a preliminary analysis of the transmission constraints attached to those projects, that they would have been far above avoided costs. Is that right?
Permit me to come back to that, Ben, because as I have said, and Ralph has said, and I believe Gary has said, and now Dave has said, we did not get back data on those 15 projects. We understood that they'd be very expensive to complete system upgrades, and therefore they were not passed back to us. So in step 2, we did not do the analysis. And as I believe you were aware, we worked with the Duke T&D evaluation team, but as CPRE is fashioned, we didn't do their system analysis. They had their own identified team. They did those numbers, and they did not pass those back to us for our step 2 analysis. You know, the re-ranking that occurs in CPRE.
Okay, thank you. Understood. Well, let me ask another question. If in tranche 1, Axion had followed the test that Orion requests, if it had used the statutory avoided cost cap as the test for cost effectiveness and not the net benefit analysis, and I understand that you don't agree that that was correct, but if Axion had done the analysis as Orion maintains it should have been done, all 15 of these projects on this table would still have been eliminated, wouldn't they?
Ben, they were, as I understand Mr. Lasaki's testimony, as long as they bid a detriment, they should get a PPA, and that's not the process. As Gary has said and others have said, we analyzed 8760 by 20 years of avoided costs. Those summary 3 indicative collapsed guidance numbers that were provided was simply a threshold to be able to participate. That it is not the same as saying if you bid a decrement, you win. It takes the further analysis. So these 15 projects, yes, they paid their security so they could be analyzed in step 2. We passed them over for step 2 analysis to the T&D team. We did not get them back. So I think it's circular here. I don't think you can draw the conclusion that if in the step 1, if we had done anything differently, other than I suppose not do the 8760 by 20 years of projected avoided cost, which we firmly believe is appropriate to determine the benefit to ratepayers.
Okay, let me see if I can narrow my question. And I will preface this by saying I absolutely understand and acknowledge that it's Axion's position that its analysis, the analysis it did, is appropriate. I am not asking you to agree that Orion's version is correct. I understand that. I'm simply trying to explore the ramifications of Orion's view of how the cost effectiveness test should have been done. And so I'll ask it this way. In step 2 of tranche 1, Axion applied the net benefit analysis as the metric of cost effectiveness, correct?
For the projects that came back to us from Duke with an assigned system upgrade cost.
Okay, understood. And it eliminated projects that had a negative net benefit after T&D upgrade costs were considered, correct?
And projects that were not sent back to us were eliminated as we were advised that they would be very expensive to serve.
Understood. So, and I'm not arguing that there were, sorry. Understood that projects were eliminated for other reasons besides cost benefit, net benefit. Understood that there are other legitimate reasons for eliminating projects from tranche 1. If instead of the net benefit analysis, Axion had used the statutory avoided cost cap as the metric for cost effectiveness and only eliminated projects that had a negative or that were above avoided cost from step 2, the 15 projects on this table, none of them would have gotten a PPA, right?
I've tried to answer your question. Gary, do you, apparently
I think,
I'm
I
failing.
think, and it, Harry, subject to a different opinion from someone else on the team, I think that is the conclusion based on applying something retroactively to tranche 1 and getting additional information to Axion to prepare the tables that have been filed in the late filed exhibit. One could make that determination that none of those would have passed that test if it had been applied and nothing else changed from tranche 1 to tranche 2, but you just kind of go back and just change the rule. I think that is Axion's opinion that yes, none of those would have passed that additional test.
Okay, thank you, Mr. Rozier. Sorry, please indulge me for a moment. I'm seeing what I can cut from my cross-examination. I have no further questions for Axion's witnesses. Thank you.
Thank you, Mr. Snowden. Mr. Higgins, any redirect examination?
Perhaps one question for Mr. Judd, just to be clear. Mr. Judd, you got some questions from council about attachment B to Mr. Lasaki's second supplemental testimony, which I will represent to you, is the clarification that Axion provided pursuant to the commission's ruling on the Orion motion to compel. Do you have that document?
I have both documents in front of me.
All right, sir. And I'm specifically referencing page 3 of the clarification, which is the table.
Yes.
My question is this, just to be clear, when did Axion receive information as to the system upgrade costs shown in that table from Duke, the Duke T&D team?
It would have been.
Was it before or after the motion to compel was issued by the commission?
Oh, it was after. It would have been in June of this year.
All right, sir. Thank you. No other questions.
Thank you, Mr. Higgins. Commissioner Gray, any questions?
No questions. Thank you.
Commissioner Dockley?
Just have one clarifying question. So there was a lot of back and forth between, and this is to Mr. Judd, back and forth between you and Mr. Snowden about the 6 projects and the other 9 projects. But I think that I just want to make sure I heard your testimony correctly. There's no distinction in your mind between the 6 projects and the 9 projects, that all 15 projects were above the statutory avoided cost, or when you were reviewing all 15 projects when they came back from the Duke team, those 15 projects were all the same in the sense that you understood that the network upgrades were going to push them above the voided cost cap. Is that correct?
Commissioner, with one slight clarification, and that is when you say we got the information back, of course, you're referring to when we got that in June of this year, because initially we were simply not given back data associated with those 15, saying that they were going to be very expensive, and therefore we did not include them in our tranche 1 step 2 analysis. That's what I believe you were asking, but I'm trying to be responsive to your question.
Right. So when you were actually conducting tranche 1, you understood that all 15 projects were going to be cost prohibitive based upon network upgrades.
Yes, ma'am.
Thank you.
But we did not, but again, we didn't have these numbers that you now see in our supplemental clarification filing.
Right, but, and that's why you did not do any type of additional analysis or net benefits test or re-ranking of all 15 projects.
That is correct, Commissioner.
Okay, and so just going back to the previous hearing then, I just want clarification. So with respect to any type of, let's just assume that and this is a hypothetical, that we agreed with Orion, the only similarly situated projects then would be the 3 projects that you stated were above your net benefit test in the first step. Is that accurate?
If I might help Mr. Judd out, if you're referring to the November 25th late filed exhibit, there were 3 proposals that had negative net benefits as a result of step 1. And Orion, if you use the Orion's approach with the maximum allowable T&D, Orion's as well as Project B, the middle proposal, would have passed that alternate screen of those 3. Is that what you're asking about?
Right, I was trying to get clarification that which other projects would be similarly situated that you may need to go back, Duke might have to go back, and if we were to rule in Orion's favor, would have to go back and potentially negotiate a PPA. And so it's your testimony that it would only be 2 of those 3 projects.
That's correct.
Okay, thank you.
And if I could,
And I'd like to add,
refer you back and refresh them on our October 28, 2020 confidential filing. We provided charts showing the impact of making the one change that's been requested by Orion. It was quite a while ago, and I just wanted to make sure that that's part of, because I think you've just alluded to what would be the impact.
Okay, thank you. And it looks like we may have, Commissioner Clodfelter, I do not see you anymore. Commissioner Clodfelter.
I'm here.
Okay, you're there.
Commissioner Duffley, this is Warren. I'm seeing a yellow signal on his, but I'm in the Dobbs building and we just lost power.
Okay. There he is.
Okay.
Commissioner Clodfelter, you disappeared for a second.
I lost all of you. I was here but couldn't see any of you. Yes, you had a question. You had a question.
So I've finished all of my questioning. Thank you, Commissioner Clodfelter.
Thank you. Gentlemen, there were times when I thought I had followed the sequence of this, but then there are other times when it got lost again. So I'm going to have to do it my way. I apologize to you for that. Will you get before you all the attachment B to Mr. Asaki's supplemental testimony? That's, and page 3 of that is the attachment, which is the chart dated June 11, 2021, which was updated after the commission's order on the motion to compel. Do you all have that available?
Yes, sir.
Okay, I have to do this my way, and that way I know I've got it clear. Look at the second proposal, which was ranked in step 1 as number 10. Okay?
Yes, sir.
All right, moving across to the right, you come to 2 columns both headed step 1, net benefit without T&D costs. One of those columns is per megawatt hour, and the second one is a total. You have that?
Yes, sir.
Am I correct that both of those calculations were done during step 1 of tranche 1?
I'm going to ask Mr. Monson, since he ran the model, to address your question.
Commissioner, those calculations were done during the process.
They were done during this tranche 1 process.
That is correct, during the tranche 1 process.
So you passed to Duke T&D team project rank number 10, which you calculated on your net benefit analysis, had a net benefit without T&D costs of $10,573,500. Right?
That is correct.
All right, the next
If
column. Yes.
Excuse me, this is Dave Ball. I might add, the process in tranche 1 provided Duke the proposal number, not the economic result. So the Duke T&D team just merely identified proposals that should move forward for evaluation in step 2. We didn't give them the economic results during tranche 1.
You told them, here's project number 10, rank number 10.
That's right.
And
well, I don't even know if they do the ranking.
Mr. Layfield?
I think Mr. Layfield could address that, but our process was generally to get back information from Duke about the transmission consequences, and Mr. Layfield and the team would then determine whether it's necessary to go forward any further with that information.
Well, did you give them the ranking, or did you just give them the group of projects and say, these have passed step 1?
I think Mr. Ball's point was, Commissioner, they did not get pricing information because under that, so we gave them the ranking, but not pricing information.
All right, so you gave them the projects that passed your net benefit analysis in step 1 in a ranked order, correct?
Yes, because the process was sequential. As projects were eliminated, because they came back to us, we then dipped into the reserve and passed new projects forward.
Yes, that is correct.
All right, so they had a project that they knew was ranked number 10. The T&D team received from you a project that they were told by you was ranked number 10 after step 1, correct?
Yes, location, the size of the project, and the like. Yes.
Got it. All right, next column moving to the right on project number 10, rank number 10, is the Duke T&D evaluation team step 2 upgrade costs. And for project number 10, the number entered there is $15 million. When did you first see that number?
Ralph, could you step, please, to confirm?
In preparation of the table, the first I saw it was concurrent with preparing the table for the response in this proceeding.
And which response was that?
Excuse me, Commissioner. This is Dave Ball. I think Mr. Layfield may be able to provide clarity, but I wanted to say I think Axion received some of the transmission information during tranche 1, and although the project didn't come back and get rerun, I think it was some cost information was shared, although since it was eliminated in step 2 by Duke, the cost information was just whatever it was when they stopped.
That is accurate.
Well, you've touched on really what I'm trying to explore with my questions is I heard several times the general statement that for these 15 projects, you didn't get them back from the Duke T&D team. And the question I'm trying to explore is that if that's correct, how then did you know whether or not any of them did or did not still pass the net economic benefit test after assignment of the Duke determined T&D costs? If you didn't get the numbers back, how would you have known in step 2 whether they should continue to be ranked or not? Project number 10 had a net positive economic benefit before T&D of $10,573,500. If you didn't get a T&D cost number back from the Duke T&D team, how would you know
Commissioner,
it failed the net benefit test at step 2?
great question. Because as we explored earlier in the testimony, the maximum allowable T&D cost was a benchmark. And when the T&D evaluation team determined that the system upgrade cost would exceed that, it was pencils down and they stopped evaluating because that number, that maximum, tells them that if we exceed that, it's going to fail our test.
Mr. Judd, you've
And
now
Commissioner,
totally lost me, because I thought that the maximum allowable T&D upgrade cost was a tranche 2 construct.
Exactly, Commissioner. And that's what I wanted to clarify here is what the Axion team had was an amount of net benefit from the project absent putting in transmission. The maximum allowable transmission cost component was solely a tranche 2 thing.
I understand that.
I apologize, Commissioner. I thought you were at the table.
I haven't gotten to that column yet. I have not even gotten to that column yet. I'm on the column Duke T&D evaluation team step 2 in tranche 1, system upgrade costs. And again, I'm trying to determine when you got those numbers.
We did not get.
I'm sorry,
Okay.
this is Dave. I think Mr. Layfield can answer that directly. I was involved in compiling information after the fact, but my understanding is that Duke T&D Step 2 evaluation eliminated these proposals. And in the process of eliminating those proposals, they passed along some cost information, but they were deemed as not eligible to proceed. And therefore, they didn't get run through our net benefit model in tranche 1. But I think we did have possession of some cost information, and that's what's in this table.
Well, here's what I'm getting at, gentlemen, is if the cost information they passed back to you, whatever it was, if you didn't then run that back through your net economic benefit model, how would you have known whether or not it passed the net benefit test in step 2? If you didn't run it back through your model.
Because we were not given the number. Included the projects were deemed to have been ones that could not go forward and therefore were not in our step 2 re-ranking approach. Ralph, is that correct?
That's a fair assessment, Mr. Jones.
Is it fair then for me to conclude that you took Duke's word for it on the 15 projects that they would fail if they were run back through the model? On these 15.
Commissioner, it is my understanding that Duke was looking at each of these 15 projects. The costs were being tallied, and the costs began to exceed the magnitude of the net benefit of step 1. However, those costs were not formalized and passed back to me, but they were passed in a preliminary form to the Axion team, is my understanding.
Was it your understanding that the Duke team was running its own version of the T&D, of the net benefit analysis as they were studying the T&D costs? And
No, Commissioner, that is not true.
Then
They
who
did not
was-
have our model, Commissioner.
Sorry?
They did not have our model.
Then who was making the determination and on what basis that the T&D costs would cause the project number 10 to fail the net benefit test at step 2?
Phil, can you address that for the commissioner?
I can certainly try. We looked at each project in ranked order. The T&D team followed the process that Axion had established for evaluating each individual bid. We have a standard document that is completed for each bid. You have seen those posted on the website. When those standard documents are completed, they are passed back to me on the Axion team. And we had information from Ralph Malsavaci that gave us an indicator of how much room we had. And when we saw the cost that the Duke team had projected as being a magnitude above what we knew the bid could absorb, the decision was made not to pass it back into the model, but to go to other bids and continue our ranked order evaluation.
That is helpful, Mr. Layfield. What I'm really trying to get at is what actually did you see from the Duke T&D team during the step 2 tranche 1 process?
We saw the results of their analysis, which I participated in the formulation of by reviewing their results in the document. The document for each bid, the analysis that was completed, that's the official transfer of information back to us. And you have all of those posted on the website, which you have been able to access.
Commissioner, if I can kind of add to what Mr. Layfield is saying, I've had too many years, I guess, in transmission and generation planning with this interaction between doing the transmission work and the generation analysis and getting people to share information. And the process is that when you take a project and it's located here, the transmission people look for where's the problem on the system, is it in a constrained area? And then they start looking at magnitudes of, well, how many miles of transmission line do I have to build? Do I need to build substations? This and all of that. And lots of times, once you go down that path, you're not close enough to being cost effective that you just shut it down at a point in time and make an experienced judgment based on the magnitudes of things of whether it's worthwhile to go forward. That was our process in this case too.
Mr. Layfield, Mr. Rozier, thank you. That's very helpful. So looking again at the chart for project number 10, which was not one of the 6 constrained projects, it was not one of those, you would have had enough information, as I understand it, back from the T&D team for you to know this one wasn't going to make it. but you might not have had a $15 million number at that time. Is that correct? Am I understanding it correctly?
Bingo. That is exactly correct.
So when was the $15 million number first surfaced to you?
I believe, Commissioner, that Ralph testified that was June of this year.
Well, Mr. Judd, I apologize to you, and I'm not sure if this has been marked as an exhibit, but it was part of the motion to compel. And there was an attachment, which was the chart that you originally provided, not in June, but back in April. And it contains a column titled Duke T&D Evaluation Team Step 2 System Upgrade Costs. And for project number 10, it includes the number of $15 million. That was in April of this year, before the June number.
I apologize, Commissioner. I did not mean to deceive you or mislead you.
I don't think you did. I'm just trying to get to the answer. When did you get that?
And I'm with you as well. We got the information as part of this process, as part of these hearings, not during tranche 1 of CPRE. And
didn't get it during tranche 1.
Correct.
Thank you.
Yeah,
Mr. Judd, that's
Dave Ball.
Thank you.
I'd like to help on this as well. It was subsequent to the closing of tranche 1 that we received a request from Duke for the system upgrade costs for all the projects that were eliminated, and we passed along information to Duke, and I can't recall, but I think it was in 2020 sometime on these projects. And what we did is we just pulled the available information that we had. They weren't completed studies, but they were the cost estimates in the files when they were eliminated, and we passed them along to Duke at the time. And I think that's my memory of when I first became aware of those transmission costs.
So this $15 million number might have been a compilation of various bits of information that you had gotten during tranche 1, but hadn't assembled or compiled until you were asked to do so.
That's correct as far as I'm concerned, and Mr. Layfield would have the direct knowledge of the information.
Is that correct, Mr. Layfield?
Yes, sir, it is correct.
Well, gentlemen, you've solved my mystery, because it also helps explain why so many of those numbers are round numbers. It's because they reflect approximations to data points that you had from an earlier period of time, but you compile those at a later period of time. I'm sorry for wearing you guys out, but I think you've answered my questions. And so with that, we're back to questions on commission questions.
Ryan does not have any questions on commission questions.
DEC does not have any questions on commission questions.
Mr. Higgins?
No questions for me. Thank you.
Wore you all out, huh? Okay, Mr. Higgins, I understand that's the panel and that there are no other witnesses for Orion, Axion?
Yes, sir, that's correct.
Mr. Higgins, I don't remember, because I got lost in my own questions here, whether there were exhibits marked that we need to have admitted. Do you have?
There are no exhibits that were marked
all right,
or attached to the testimony.
That's great. If that's the case, then Mr. Jurak, we're with you.
Thank you, Commissioner Clodfelter. With your permission, at this time, I'd like to call the panel of Orvane Piper and Phil Cathcart on behalf of Duke Energy Carolinas.
Mr. Piper, Mr. Cathcart, will you both raise your right hands? Do you and each of you solemnly and sincerely affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do. I do.
Okay. Madam Court Reporter, let the record reflect that both witnesses gave the affirmation. Mr. Jurak.
Thank you. Just by way of introduction, Mr. Cathcart, will you please state your name and title for the record?
Phil Cathcart, Renewable Compliance Manager.
Thank you. Mr. Piper, would you please state your name and title for the record?
Orvane Piper, Senior Engineer and Transmission Plan.
Thank you very much. And Mr. Cathcart, along with Mr. Piper, did you prepare and cause to be filed in this proceeding direct testimony?
Yes.
Yes. Mr. Piper, did you assist in the preparation of that pre-filed testimony?
Yes.
And do either of you have any changes to make to that pre-filed testimony at this time?
No.
Mr. Cathcart, if I were to ask you the same questions contained in your testimony today, would your answers remain the same?
Yes.
Mr. Piper, if I were to ask you the same questions contained in your testimony, would your answers remain the same?
Yes.
Thank you. Commissioner Clodfelter, this time I'd request that the pre-filed direct testimony of the panel of Orion, Piper, and Phil Cathcart be copied into the record as if given orally from the stands.
Hearing no objection to the motion, the motion will be allowed. Mr. Jerack, we have previously admitted into evidence the late filed exhibit, so it's not necessary to mark or move that. And my recollection is that you don't have any additional exhibits that need to be marked for these witnesses, correct?
That's correct.
Okay.
And thank you, Commissioner Clodfelter. We do not have a witness summary given the brevity of their testimony, so the witnesses are now available for cross-examination.
Let's do this. Mr. Higgins, any cross-examination, or Mr. Crisp on behalf of Axion?
No, I have no cross-examination for the Duke witnesses. Thank you.
Okay, Mr. Snowden, they're all yours.
Okay, thank you, Commissioner. Mr. Cathcart, Mr. Piper, good morning. Mr. Cathcart, I have a couple of questions for you. So your responsibilities as described in your testimony include compliance with CPRE program requirements and interfacing with the CPRE independent administrator. Is that right?
That's correct.
Okay, and you talk about the late filed exhibit in this docket in your testimony. Is that right?
That's right.
Okay. What was your role in the preparation of the late filed exhibit?
I collaborated in putting it together.
Okay, can you be a little more specific?
So our understanding was the exhibit was to identify some of the complexities. If the commission decided one way or another in the legal decision that was brought up in the hearing in November. So this late filed exhibit was an attempt to identify some of the complexities that could come up.
Mm-hmm. Okay, so you reviewed the statements in the late filed exhibit before it was filed, correct?
Correct.
Okay, and in your testimony, you affirm the accuracy of the statements in the late filed exhibit. Is that right?
Correct.
Okay, thank you. Mr. Piper, I have similar questions for you. In your testimony, you say that your responsibilities include coordinating generator interconnection studies, including the evaluations that were performed for CPRE. Is that right?
Yes, that's correct.
Thank you. And this would include the analysis of T&D upgrade costs that was performed during step 2, correct?
Yes, that's correct.
What was your role in the preparation of the late filed exhibit?
Reviewing any information that I was asked to review, as well as helping to discuss some of the complexities that may come up.
Okay, thank you. And in your testimony, you affirm the accuracy of the statements in the late filed exhibit. Is that right?
Yes, that's correct.
Okay. And I guess these questions would be for either Mr. Cathcart or Mr. Piper. As discussed, Duke collaborated with Axion in the development of the late filed exhibit. Is that right?
That's right.
Okay, and could you describe that collaboration process a little bit?
Well, there was certainly collaboration in getting the table at the end of the late filed exhibit included.
Okay. So as I understand it, and as we've discussed, Axion compiled the table at the end of the exhibit. Is that right?
That's right. So, sort of the nature of the process is some separation. So there was some information that Duke would have and some information Duke would not have.
Okay. And Duke discussed with Axion the contents of the table at the end of the exhibit. Is that right?
There was some Duke input on the table, yes.
Okay. Was Axion involved in the preparation of the narrative portions of the late filed exhibit?
Not to any major extent.
Okay. Do you recall whether Axion reviewed the narrative portions of the late file exhibit before it was filed?
I don't recall. I understand from their testimony they did not.
Okay. Okay, thank you. If you will indulge me for a moment, I'm going to breeze through a lot of my prepared cross since we've already covered it. So give me just a moment, please. I believe this would be for Mr. Cathcart. Mr. Cathcart, if you could take a look at page 6 of the late filed exhibit, that's item 5, where it says overall CPRA target procurements. Do you see that?
Yes, I have.
Okay, thank you. Now it says here in the second paragraph that the retroactive procurement of 2 additional projects would increase the risk of over procurement for CPRA. Is that right?
That's correct.
Okay. And by 2 projects, that refers to the Orion project and the one other proposal that was eliminated in step 1 that might have been or would have been below avoided cost after T&D upgrade costs were considered. Is that right?
There was potentially 2 projects similarly situated to Orion that were eliminated in step 1 of tranche 1.
Okay, well, I'd like to turn your attention back to page 5 of the late filed exhibit, where you see where it discusses bid A and bid B.
Yes.
Okay, and so bid A and bid B, those refer to those 2 other projects that were eliminated in step 1. Is that right?
Those are the 2 I was referring to.
Okay. Okay. Actually, I'll move on from that. So going back to the statement about a hypothetical retroactive procurement of the 2 other projects. You say that the hypothetical retroactive procurement of those 2 other projects would increase the risk of over procurement for CPRE. Is that right?
That's right.
Okay, but not that's not in reference to the Orion project. Is that right?
So the under collection or under procurement in tranche 1 was rolled into tranche 2, and Orion was selected in tranche 2. So in the overall CPRE procurement, Orion is included. So a change of decision in this case, essentially only the bid A and bid B would be additions to the CPRE procurement.
Okay, so Orion's proposal is already factored into Duke's calculations of its progress towards CPRE targets. Is that right?
That's right.
Okay, and awarding Orion's request, if the commission were to award Orion's or grant Orion's request for relief, that would have no effect on Duke's progress towards its procurement targets. Is that right?
It would not change procurement targets, only cost to customers.
Okay, and Orion has not requested that the commission award PPAs to these other 2 projects that were eliminated in step 1 of tranche 1, has it?
I have not heard that request from Orion.
Okay, and to your knowledge, those projects have not come forward and requested tranche 1 PPAs, have they?
I'm not aware of the 2 similarly situated projects requesting similar relief, but I would feel a bit of an obligation to, because they are exactly similarly situated, if we unwound the tape and changed the rules, it would seem appropriate to do the further analysis on those 2 projects and determine if they would be eligible for a PPA.
Okay. Well, just to put that, if we were to unwind the tape and go back to tranche 1, even if those two other projects had been awarded PPAs in Tranche 1 and Orion were also awarded a PPA in Tranche 1, Duke would still have been under its procurement target for CPRA Tranche 1. Is that right?
I believe that is correct.
Thank you.
I hate to not mention that whatever happened in Tranche 1 affects what our procurement target is for Tranche 2. So because we were low in Tranche 1, we had a higher amount in Tranche 2.
Understood. Thank you.
Which has been completed.
I'd like to go back to page 1 of the late filed exhibit. If you've got that handy in the third paragraph. As discussed in the third paragraph, the late file exhibit includes a calculation of the maximum allowable T&D upgrade costs for the Orion proposal and for the two other proposals that were eliminated in step 1 based on the net benefit analysis. Is that right?
That's right.
Okay. What was the purpose of including that information in the late filed exhibit?
I'm going to scroll down to the table. So I believe the main intent of including that was to demonstrate that there were, in fact, two similarly situated projects to Orion.
Okay, well, what was the purpose of including the maximum allowable T&D upgrade costs for those projects in the late filed exhibit?
Let's see. Well, so in the next sections, we go on to demonstrate that those projects, best we can tell under certain scenarios, may go on to fall under the avoided cost, but because we've had some changes in equipment classifications and the standard upgrade package, that we would need to be told how to evaluate these projects, because under different scenarios, they may not be able to move forward towards a PPA.
Okay, thank you. So at the time this information was included in the late filed exhibit, as I understand you're saying, it was understood that the way to determine, or one way to determine whether a particular proposal was below avoided cost would be to compare the maximum allowable T&D upgrade costs to the actual upgrade costs as determined by Duke. Is that right?
I'm a little hesitant to answer. That maximum allowable upgrade cost was determined by the independent administrator, and I think what I understood was it was based on net benefit when it was created during Tranche 1.
Well, did you hear the testimony today that maximum allowable T&D upgrade cost was a Tranche 2 construct?
I did.
Okay. And my understanding is that, and did you hear the testimony earlier today that of Axion's witnesses that that construct was created to determine whether a particular project would be below the statutory avoided cost cap as after consideration of upgrade costs?
That was a Tranche 2 concept applied to the 15 proposals that were eliminated in step 2 of Tranche 1. I don't recall hearing what that number in this table was, what basis it was created on in the late filed exhibit, whether it was net benefit analysis or what I've heard you call the statutory avoided cost cap.
Okay. Well, let's look at the table, and this is in the last column on the last page of the late filed exhibit. You see where it says maximum allowable T&D upgrade costs?
I do.
And then you see where it says see February 28th, 2020 IA memo?
Yes. Yes.
Okay. Do you know what memorandum that is referring to?
I'm familiar with that. Yes.
Okay. So you recall that memorandum?
I do.
Okay. Do you have a copy of Orion's verified petition in this matter?
I'm not certain. Can you describe it more?
Sure. It's the initial petition in Orion's matter, and there's a copy of that memorandum that's attached as to that petition. It was also introduced for benefit of the commission and the lawyers. That was also introduced as an exhibit during the November hearing. But the easiest way to find it is as an attachment to the petition. Do you have a copy of that petition?
If I may.
Yes, Mr. Jarrett.
To the extent that the questions, this line of question tends to go down and ask questions regarding the contents of the February memo, we would object to those questions as being outside of the scope, the narrow scope set for this hearing. So I wanted to take that question out before we go down a long line of questions on that topic.
Thank you. Understood, Mr. Drack. And just to be clear, do not intend to talk about the memo other than to just establish what this maximum allowable T&D upgrade cost concept is. So we're not going to be asking about the preparation of the memo or anything like that.
All right, well, let's ask the question about what the concept is, and then we can move from there.
Okay. So, Mr. Cathcart, I'll just read from this, and you can tell me if this sounds right. So I'm looking, this is item 5. It says the step 2 evaluation will include a calculation of the maximum allowable T&D upgrade costs based on the proposal's price decrement below the 20-year levelized avoided cost rates identified in the RFP. Does that sound right?
Excuse me.
Yeah.
Commissioner Potfield?
Mr. Jarrett?
I would object to this question. The witness does not have a copy of the petition. Mr. Snowden is simply reading from the petition and asking the witness to confirm the accuracy of his reading. I'm not sure what the value is or relevance of this question.
Mr. Snowden, we don't have the document. It's not marked as an exhibit. It hasn't been designated prior to the hearing. If your purpose is to ask him what he understands the concept to be, you can ask him what the concept to be, but reading to him from a document and asking him to verify what the document says is getting us a little far afield here.
Understood. Thank you. Yes, and as I mentioned, this has been, it was not included as a cross-examination exhibit, but it was marked as an exhibit during the November hearing. If it would be helpful, I can simply share a copy of the exhibit. I don't need to have it marked at this point.
I think if the witness doesn't have access to the exhibit, we really shouldn't be asking questions about it. If you can provide access, and it was marked in the November hearing, let's give the witness access to the document.
I was not in the November hearing, and I don't know that I'm the company expert on that memorandum.
Okay. Okay. Well, we'll skip the memorandum, and go back to the late file exhibit. It's your understanding, though, Mr. Cathcart, would you agree that this, the last page of the late file exhibit, where it says maximum allowable T&D upgrade costs, indicates that metric is the same as described in the February 28th, 2020 IA memo. Is that right?
I mean, kind of along the lines of the last few questions, that seems reasonable, but I cannot confirm that.
Okay. Okay. So you don't know. I understood. So do you not know the? Let me ask you this. Would you agree with the testimony of Axion's witnesses, or would you agree that Axion's witnesses testified today that for a particular proposal, one way to determine whether that proposal is below the avoided cost cap is to compare the upgrade costs with the maximum allowable T&D upgrade costs?
I agree that that's a reasonable approach.
Okay. And so would you agree that the apparent purpose of including that information in for these 3 projects eliminated from in step 1 in the late file exhibit was to demonstrate or to elucidate or provide information on the question of whether those 3 projects might have been below the avoided cost cap?
Yes, this information demonstrates that the three projects, Orion, Bid A, and Bid B, are similarly situated.
Okay. So my question is this. Well, wait just a minute. Let's look at page 7 of the late filed exhibit, if we can. Are you with me?
I am.
Okay. And it says here that 15 projects were also eliminated in tranche 1 based on a determination of negative net benefit after the application of T&D costs. An extensive further analysis would be needed to assess each such proposal to determine whether the applicable T&D costs would have exceeded the maximum allowable T&D upgrade costs. You see that?
I do.
Okay. Do you think that's still true today?
So at the time this was written, it was certainly a concern. Based on the commission order to do the extensive research and determine what the numbers were that we needed to evaluate these projects, I would say these 15 projects are no longer a concern. If I were the complexities I'd be most concerned about are the projects eliminated in step 1.
Okay, thank you. Question is this: if we were able to establish that these 15 projects are not a concern based on looking at the maximum allowable T&D upgrade costs, why wasn't that information included in the late filed exhibit when it was filed back in November?
Duke did not have the calculation. The calculations to determine if these projects would be above avoided costs.
Okay, and do you recall whether you discussed with Orion whether it would be, with Axion, whether it would be appropriate to include that information in the late filed exhibit at that time?
It was our understanding that Axion did not have the calculations, and that to go through these extensive calculations was beyond the scope of creating a late filed exhibit.
Okay, thank you. I have no further questions. Thank you very much.
Thank you.
All right, any redirect?
Just one brief question, if I may, Commissioner Clodfelter.
Sure.
Mr. Cathcart, Mr. Snowden was asking a number of questions about the preparation of the late file exhibit. Do you happen to recall that Duke did in fact share the late file exhibit with Orion in advance of filing it with the commission?
Yes, I do recall that.
And do you recall whether Orion offered any substantive feedback or any feedback at all regarding the late file exhibit at that time prior to filing?
I do not recall that they gave any feedback.
That's all the question, all the redirect I have, Commissioner Clodfelter.
Thank you, Mr. Chirac. Questions from commissioners? Commissioner Gray.
No questions.
Commissioner Duffley.
Yes, I have several. So with respect to the similarly situated projects, I just want to obtain some clarification regarding that. We heard an Axion witness today state there was only one similarly situated project to Orion. And also, if you can look at your January 4th, 2021 filing.
Commissioner Duffley, which file are you referring to?
It is post-hearing brief of DEC.
I don't believe that witness Cathcart has a copy of that in front of him. I can certainly communicate it to him, convey it to him electronically if it would be helpful to you, Commissioner Duffley.
Okay, I can read it to you on page 13 of this brief submitted by DEC. It states the challenge. So on the previous page, it says other complexities and challenges associated with a retroactive change to tranche 1 results include the following. And then if you go to page 13, it states the challenge of retroactively assessing the T&D costs for the one similarly situated proposal that was not previously assessed.
Commissioner, I understand the confusion there. So there were there were a total of 3 projects eliminated in step 1. So one of those is Orion. Another of those was exactly similarly situated to Orion, where they were eliminated, but in an effort to expedite the process, the T&D sub-team did take a look at that project and determined that they did not have substantial network upgrades.
And which project was that you say is exactly similar to Orion?
This was bid B, as described in the late file exhibit.
Okay.
So
I'm interrupted. I'll let you continue.
Yeah, and then I think the confusion was my answer that there were 2 similarly situated, and you mentioned that a Axiom witness described 1. So when I said there were 2 others, I was referring to 2 others eliminated in step 1. So one of those exactly the same, bid B, that had some thermal studies completed so that we understood they did not have major system upgrades. The third project is bid A, which the Duke T&D sub-team has not performed any study on. So there's potential that they have no upgrades and would be exactly similarly situated. There's potential that they have substantial network upgrades and may not be able to proceed with imputed upgrade costs.
Okay, so the similarly situated proposal on page 13 of your post-hearing brief is bid B, correct?
That sounds correct.
Okay, and then bid A, you're stating that you do not have the information currently that would suggest that it is similarly situated or not similarly situated to Orion.
That's correct. That project was eliminated in step 1, not passed to the T&D sub-team, so we've not performed any studies.
Okay. And so, and going to the chart, that late filed exhibit with the 3 bids, if you could turn your attention to the far right-hand corner. And it says Duke T&D Evaluation Team Step 2 System Upgrade Costs. You see that?
That's right.
Column?
Yes.
And so that's what you're saying in that column, that is unknown.
That's correct.
Okay, thank you. And in Duke's latest filings in docket numbers E2 sub 1159 and E7 sub 1156, are you familiar with those filings?
I am.
You are, okay. So, and Duke's indicated in those filings, am I correct, that there's currently, based on current information, looking at the transition megawatts, that currently there's approximately 112 megawatts of additional projects to be procured through CPRE?
I don't have it in front of me, but that magnitude sounds correct. I'd like to maybe stress a little more that there's a lot of assumptions that go into creating that number. It certainly could be across a greater range.
And do you see that changing significantly or not?
Well, this commission has recently asked us for an update, and we've done a lot of work towards it and identified a lot of potential projects that could come through before the end of the 45-month CPRE window. And I believe what we've requested is a little more time to take a look at these closer to September.
So it's still not clear with respect to over procurement or under procurement?
That's correct.
Currently. Okay, thank you.
It's unknown.
Okay, those are all my questions. Thank you.
Thank you.
Mr. Cathcart, Mr. Piper, I'm going to try to short circuit a lot of what I went through with the Axion witnesses, but I'm going to refer again to this attachment B to Mr. Lasaki's supplemental rebuttal testimony. Do both of you have access to that?
I do.
And again, I'm referring not to tranche one. I mean tranche two. I forget tranche two. I'm referring only to the state of the world as it existed in tranche one. And I'm looking at the column that's titled, it's the fourth column over from the right-hand side. It's titled Duke T&D Evaluation Team Step 2 System Upgrade Costs. You have that column? And it is my understanding of the testimony from the Axion witnesses that the numbers in that column represent Axion's informed and educated summary of cost information that they received from the Duke T&D evaluation team during step 2. Is that correct? Is that what those numbers are?
Orvain, I don't know if you want to speak up or I can.
Yes, it is my understanding that those numbers were provided by Duke via T&D sub-team at some point in the process. I haven't cross-referenced those numbers, but it's my understanding that they came from DEC.
Well, okay, look at the second line, which is project ranked number 10 in step 1, and the number in that column was $15 million, a perfectly round number. My understanding of the Axion witnesses' testimony is that Duke T&D team didn't give them a $15 million number. It gave them sufficient numbers and cost data from which they could determine that the order of magnitude of the cost was going to be in the range of $15 million. Is that accurate or inaccurate?
Because I wasn't involved with the preparation of this specific table, I don't know the trail, but we did provide high-level feedback to Axion throughout the process regarding the bids that are included in this table and issues that they would be facing if they would move forward in the evaluation process.
Right. Mr. Piper, that's a fair answer, and I think that answers the question I was really getting at. So that's all I have for you. Thank you. So let's see if there are questions on the commission's questions.
Commissioner, I've got a few questions on Commissioner Duffley's questions.
All right, proceed.
Thank you. Mr. Cathcart, Commissioner Duffley, you recall, asked you about the 2 other projects that were also eliminated in step 1 of tranche 1, bid A and bid B. Is that right?
That's right.
Okay. Would you please take a look at page 2 of the late filed exhibit?
Just a moment. Okay, I have it.
Okay, and this is item 2, and you see the bullets labeled bid A and bid B, right?
Right.
Okay, and then you see in the bid A bullet, it says that the company has confirmed that no tranche 2 projects would have been impacted had this project been selected in tranche 1. You see that?
Yes.
Okay, and you see where it says this project was already assumed in the base case for studying tranche 2 projects. Is that right? Is that right?
This project would have been in the base case for tranche 2, yes.
Okay. So as I read this, the implication to me is that if this bid A project were retroactively selected for a PPA, it would not cause any problems on the interconnection side because it was already assumed in the base case for tranche 2. Is that right?
That's right. Maybe another way to say it is it would not disadvantage any of the tranche 2 projects.
So you wouldn't have to rerun the tranche 2 study if this project retroactively got a PPA, right?
It was in the base case. We would not rerun the study.
Okay, and that's also true of bid B, correct?
That's right. That's how the CPRE rules were written, so that's correct.
Okay, thank you. So as I understand it, the only, if these projects were to be retroactively awarded PPAs, the only complexity that would arise would be the impact on Duke's overall CPRA procurement targets. Is that right?
A little more than that. We would need to actually run the studies on bid A, and we would certainly, there's the PPA cost windfall to Orion for moving from the Tranche 2 PPA to the Tranche 1 PPA. So there's a cost impact.
Okay, well, I'm focusing on bid A and bid B here. What I think I heard you say was that you would still have to figure out, to do some additional study to figure out if both these projects were below avoided cost. Is that right?
Certainly for bid A, and then for bid B, we would need clarification on whether we should retroactively apply some of the equipment classifications that have changed. What would be the most appropriate way to look at bid B, similar to how would we go back and look at Orion and determine, can we keep them below avoided cost?
Understood. Thank you. So I guess what I'm hearing you say is that it might be complicated to figure out whether and how to deal with a PPA for these projects, but even if you went down that path, it wouldn't screw things up for everybody else in CPRE. Is that fair?
DEC is not concerned about the other Tranche 2 winners.
Okay, thank you. And going back very briefly, Commissioner Duffley had a couple of questions about where Duke is on its overall CPRE procurement targets. And I believe that she said, and you agreed, reading from Duke's recent filings in the CPRE dockets, that at this time, Duke's best guess is that about 112 megawatts of projects would still need to be procured through CPRE. Is that correct?
That magnitude sounds correct, yes.
Okay, okay. And if you don't mind looking at the last page of the late filed exhibit to the table.
Yes. Yeah.
Okay, actually, I guess we don't know on this what the total generating capacity of bid A and bid B are, do we?
It's confidential on this table.
Okay, on this table. Do you know what the total megawatts of those two projects are?
What I don't know is my ability to discuss confidential information in this proceeding.
Do you know whether the total, and if you can say whether the total capacity of those two projects is over or under 112 megawatts?
This is my first time up here, so I don't know if I can call in my lawyer.
Yeah, I believe that information, the size of the project is confidential. The other bid A and bid B has been designated as confidential information.
Okay. Thank you. But okay, I have no further questions. Thank you, Mr. Cathcart.
Thank you, Mr. Sims.
Mr. Higgins, anything from you on Commission's questions?
No, sir. Nothing for me. Thank you.
All right, Mr. Jurak.
Yeah, Mr. Cathcart, just briefly, some questions that your questions from Mr. Snowden and others about sort of the retroactive treatment of these three projects, Orion and the other two.
Now, hold on. These are not questions in response to Mr. Snowden's questions. These are questions on the Commissioner's questions, okay?
Okay.
Okay.
Thank you. Apologize. So as we think about, Commissioner Duffley's asking about the other two similarly situated projects. Do you recall those questions?
I did.
Okay. And these are bids that were bid into Tranche 1, correct?
Correct.
And the avoided cost cap in Tranche 1 was a higher avoided cost cap than was applied in Tranche 2, correct?
Correct.
So all things being equal, the bids that were submitted and potentially selected in Tranche 1 are higher price bids than were bid and selected in Tranche 2, correct?
That is correct.
I have no further questions.
Okay, Mr. Jurak, anything further from Duke?
No, sir, we have no further matters for the commission's attention today.
All right, I think that brings us to the end. Just for good order's sake, let's just be sure that any exhibits that have been marked for identification, but that we haven't, I haven't yet done the proper thing and allowed their admission, we'll admit them into the record now unless there's some objection. It may not be necessary to do that, but just in case it hasn't been done, we'll do it. No objection. All right, folks, that brings us to the end. Again, we're trying to get a decision made here before we lose Commissioner Gray. And so I'm going to ask you if the parties would agree that we can shorten the time for briefs after you get the transcript of today's hearing to 15 days from transcript. Again, because you've already filed post-hearing briefs on most of the issues already. You've already done that. So your post-hearing briefs today should really just address the late filed exhibit questions. And I'm hoping you could get that done within 15 days. I understand we've got a holiday, otherwise I would have made it 10 days. But unless you've got serious objections to that, somebody's going on vacation or whatever, will 15 days from transcript work?
Yes, sir.
Yes, that'd be acceptable.
Thank you. Thank you both. Again, we're trying to hurry this along before we'll lose Commissioner Gray. And let me remind you too that I would like to hear from you by letter by the end of the business Tuesday, that if we lose Commissioner Gray before we've gotten our act together on a decision, that we can allow Commissioner Brown-Bland to participate in the decision by having read the record. You don't have to say yes, you don't have to say no, but I just want to know your position. If you do consent, we'll proceed on that basis. If not, we'll drop back and figure out what other options we may have.
Commissioner Clodfelter, I'm sorry to interrupt. If I may, I've previously discussed that with my clients and Orion consents. Should we also go ahead and file a letter? Do you need that letter, or can we just say it here?
Well, we'll take your consent on the record. It's on the record, so that's sufficient.
Thank you.
I'll accept that. That's fine. All right. Are there any other matters we need to take up this morning? All right. I have only one. Linda Garrett, my apologies to you for not taking a break, but I had a hunch if we went a little longer this morning, we'd get to the end. So my apologies to the court reporter. And if there's nothing else, then we are adjourned. Thank you all for your participation this morning. Appreciate it. Thank you.
Thank you.